Today's video says about one issue pertaining to the Trademarks Act. The issue is whether a criminal action can be taken against the proprietor of a registered trademark. This is the issue of this video today. Let me say something in this regard. Suppose I am a registered proprietor of the trademark and anybody is willing to take an action against me as far as section 102 to 105 of the Trademarks Act 1999 is concerned. Whether that criminal complaint is maintainable against me because I am registered proprietor. Before I go ahead, let me say something in respect of section 28 subclause 3 of the Trademarks Act 1999, which says that when there are two registered proprietors, both can have an exclusive right to use the said trademark in their separate name. Meaning thereby one registered proprietor cannot take any action against the another registered proprietor as per the section 28 subclause 3. Now this is in respect of civil remedy. Now after this, let me say about the criminal remedy which is available under the Trademarks Act 1999. But the section or the section is very crucial. I am going to discuss this section, but the issue is, as I said, I am registered proprietor, whether any criminal action can be taken against me. Let me give this answer. The answer is section 110 of the Trademarks Act 1999. Let me discuss this section entirely. The section says that 102 to 105 are subject to the rights created or recognized by the Trademarks Act in relation to the registered trademark or proprietor of such mark. Meaning thereby, if I am registered proprietor 1, then this section 102 to 105, these sections are related to falsifying the trademark. The section is for taking defense. Now, whether these sections are applicable to me or not when I am registered proprietor. The important line as far as this provision is concerned is subject to the rights created or recognized by the Trademarks Act. The question arises, how can a right be created or recognized under the Trademarks Act? Answer is section 28 subclause 3, second section 31. I have already made one video in respect of section 28 subclause 3. You may find that particular link somewhere on the screen. So that let me discuss or let me say something about section 31 of the Trademark Acts. What does it say? 31 says that the title registration to be prima facie evidence of validity. Registration of the trademark, registration certificate, if I give the certificate of that particular trademark, then this is prima facie valid. Now, what does that section say deeply? Let me read that section. In all proceedings to a trademark registered under the Trademark Act, the original registration of the trademark and all subsequent assignment and transmissions of the trademark shall be prima facie evidence of the validity thereof. The section begins with in all legal proceedings. In all legal proceedings include criminal proceedings. Second portion of section 110 says like this: no act or omission shall be deemed to be an offence under the section 102 to 105 if, that means there is condition, if the alleged offence is related to a registered trademark and the act or omission is permitted under the Trademark Act. This is 110A. If there is an allegation against me because my trademark is registered and I am registered proprietor, and the act or omission is permitted, the act and or omission, the act and omission means it is not clarified in the Trademarks Act. So that we have to understand that act means the registration of particular trademark, or the act means falsifying of the trademark. But plain reading of this section indicates that registration of the trademark, the act of the registration of the trademark. The alleged offence is related to a registered trademark and act or omission is permitted. That means the registration of that particular trademark is permitted, then no offence is committed against me because I am registered proprietor. This is the explanation of A. Now what does B say? 110B. The alleged offence relates to a registered or an unregistered trademark and the act or omission is permitted under any other law for the time being in force. Under any other law for the time being in force plays very important role as far as this section is concerned. Now one word, unregistered trademark, registered or unregistered trademark. So whenever there is a question of unregistered trademark, my rights are always open as far as the common law remedies are concerned. Second, any other law, this term any other law for the time being in force also related to any other act. For example, Copyright Act, for example, Design Act. If my trademark is registered under the Copyright Act, that is the label, is registered under the Copyright Act, and for the same label, if somebody has filed a complaint, criminal complaint, and if I show that registration certificate under the Copyright Act, then whether that criminal complaint under the Trademark Act 102 TO22 105 is maintainable? The answer is no, it is not at all maintainable as per the provisions of 110 subclause B. This is the explanation of B. In this regard, let me discuss one judgment, the judgment of Honorable Mumbai High Court. In para number 26 of that judgment, in the case of Anand Tukaram Teke and others versus the state of Maharashtra, decided on 24/9/2018, criminal complaint 1471/2013. This is the case wherein the same defense was taken in respect of the registration of the copyright and the criminal complaint under Trademark Act. As far as section 110 is concerned, the case, no case is made out, was decided by Honorable Mumbai High Court. So the answer of our query or the issue is, when the mark is registered, 1, in any other act, 2nd, or in under the Trademark Act, no case is made out. However, that registration should be valid. It should not be taken by fraud or by any dishonesty or with malafide intention. These are the criteria. So if valid place, that in section 28 the word if valid, and it is given this if valid is given in section 28. As far as the crux of if valid, the term of if valid is also given in section 110. The act or omission is permitted by the Trademark Act. That means if the registration is permitted by the Trademark Act, then no offense is made out. Friends, I hope you like this video. If you like this video, don't forget to subscribe my channel. Thanks a lot.